what comes to mind now is trying to look at the appointments of some of these people. And a case in point, perhaps let's bring this before you, the NJC and the Rivers State Chief Judge matter. Take us through the processes and before we go further to see what exactly it is as we speak now.
You see, it's a very funny situation we have in Nigeria. We feel we are in a federated country and that all arms of government are based on the federation. But one has to now know that there is only one single bar in Nigeria. Also, there's one single judiciary. Despite and in spite of what you call federalism, this is the only area in Nigeria today that has a unified form of a system. There is a single bar in the sense that a lawyer in Lagos can go to Abuja and practice, can go to Owerri and practice, can go to Kaduna and practice, because there's a single bar in Nigeria. There's only one law school in Nigeria. Also, there's one judiciary. Therefore, the problem that is arising from what is happening in Rivers State is that the form of appointment of CJs or judges as prescribed in the Constitution makes it very, very difficult. It is, the Yoruba say, arometa in dobenu, that is, a three-legged pot will not throw away the soup. Under the Constitution, there are three methods of appointing a CJ. First, the state commission.
Judicial Service Commission.
Yes, will recommend maybe 3 judges or 2 judges to the National Judicial Commission. The National Judicial Commission will now look into it again and recommend to the governor. At that stage, the governor will now appoint. But in appointing, he also has to send it to the House of Assembly for ratification. So you find that the only person who has the power of appointment is the governor. But the governor cannot appoint except upon the recommendation of the National Judicial Council. So you now find that it is a three-legged system, and it has never been tested.
So all three must be on the same page.
Oh yes, there must be a recommendation from the State Judicial Council to the National Judicial Council. From the National Judicial Council, it comes back to the state governor that, okay, we have screened these candidates. We believe this is due, to be appointed. He now does the appointment. But even then, his appointment at that stage is not final. He still has to send it to his own House of Assembly for ratification. So you will find that the only person who has the power to appoint is the governor. But despite and in spite of that, he cannot do it alone, except upon the recommendation of the Judicial Council. People have queried this system, that why under a federation should the governor of a state, relinquish power to a unified, federal commission before he can take a decision. But we have to look at it from the perspective of Nigeria today. I believe the system is okay. But because it has never been tested, as it's been tested in Rivers State now, we have not seen the shortcomings. For the past 50 years we've been doing it, we haven't got problems. Now we have a problem. And what is the problem? The problem is this. The Rivers State wanted a particular person to be the CJ. People say yes, he was in the former judiciary of the High Court. But he has moved from the High Court and he has gone to the customary court, as you know. The question then is there a difference between the customary judge in a state and the High Court judge in a state? Also, is there a difference from somebody who was the most senior in the High Court now being transferred or appointed? Again, that's where the problem comes. When you are taking a senior member of the bench from a state and making him the chairman of the customary court, are you giving him a new appointment or are you transferring him? Because it's very important to know that difference. If it is a transfer, he still remains in the judiciary of the High Court. If it's a new appointment, it means he has relinquished his post as a High Court judge to take up this appointment. That has to be solved. Now, when the post became vacant, the governor was looking at this man who was transferred or appointed from the bench of the High Court to the customary court as the most senior. And therefore, when the names were sent with the second name, the Judicial Council now said, look, this man is not part of the judiciary. He's not part of the bench of the High Court because it is not a transfer, it is a new appointment. Therefore, the most senior now should be given. That is where the problem started. They now said, Abba, I am the government. I have the sole prerogative to appoint. I am not bound to accept because there's nowhere in the Constitution that says it's bound. Say, but let us give it a trial. They now went to the court. Justice Alabi, Lambo, now took up, with great respect to the judge, what was presented before him, actually what he decided. But he did not say, appoint this man. But from the way the application was couched, the Rivers State, oh yes, we have now a free hand to go along and appoint this gentleman. The question now is, by disregarding the recommendation of the NJC and appointing somebody else without their recommendation, the NJC now said, look, you can't do that. They suspended him. I am of the view that under the law, if you don't have the power of appointment, you cannot suspend. That is my view. I was on the flight yesterday with a former president of the Bar Association. And I asked him, where is the power in the Constitution for the NJC to suspend when they don't have the power to appoint? They only have the power to recommend. He says it is derived from the interpretation at law. And I said, no. So it's a moot question, which I believe the present national conference that is going on should look into. If you don't have the power to appoint, can you suspend?
And you said we haven't actually tested this before, and since
We have never tested
this
it.
is the very first time we're getting into this kind of imbroglio, as it would seem, is there a way out of it?
Well, the way out of it is to sit down, as the national conference is going on now, to look at this situation, because it has been opened up now. Very soon in Lagos State, there's going to be a vacancy. The CJ of Lagos State is leaving this next month. The same scenario might play itself out again. And we don't want legal matters to be going to court. And I'll tell you why. The Rivers State have carried this matter to the court. At the end of the day, when appeals are made, this appeal is going to end in the Supreme Court. The chairman of the Judicial Commission is the Supreme Court, is the Chief Justice of Nigeria. The nomenclature of the National Judicial Commission is made up of the Chief Justice, his deputy, the head of the Court of Appeal, other judges, Sharia, and they bring in some noted lawyers. But when it comes to the question of discipline judges, the lawyers are asked to walk out. And it stands to reason. When a lawyer is still going to go before a judge and say, my lord or my lady, why should you sit when you are disciplining a judge? So the lawyers who are in the committee of the commission are not allowed to sit when disciplinary actions are being taken. Now, the problem is, when this matter gets to the Supreme Court, the judge who has been disciplined and who filed this case and finds the CJ sitting in the panel. I remember the issue of Abiola. Abiola was asking for bail from the Supreme Court. And late G.O.K. Ajayi, his lawyer, looked at the panel of judges. It was late Bello who was presiding and says, look, I don't think I can expect justice from this panel. You have been bribed by Abacha, you are given Mercedes-Benz car, so I don't think I can get justice from you. Justice Bello, a very gentleman, to the core. Oh, said, G.O.K., is that it? You think we cannot deliver justice to your client because we have been bribed? Now, we will excuse ourselves. Unfortunately for Abiola, the number of required to form a panel in the Supreme Court, outside those 5 that have been swept out, they couldn't find another panel. And that was why Abiola's the bill could not be, heard. Now, the scenario may play itself this time. If the retired judge, the suspended judge, gets to the Supreme Court and finds, 2 judges there who are, and it says, look, I don't think you can't be a judge in your own right. I don't think I will get. That's where problems will start from. So the earlier we look at these things and see how we can, manage it. But as I said, ideally, we should not have a uniform system of judiciary because this is a federation. We should allow states to determine who is the CJ of a state rather than allowing a committee, to dictate, to the state.